I'm James Cordes. I'm a family law attorney. I've been practicing in Colorado for about 15 years. I'm a partner at Kinnett Cordes, where I practice collaborative law, divorce law generally. I'm also an arbiter, decision maker, and a mediator as part of my practice. So collaborative law is an alternative dispute resolution process for family law cases. And the practice was formalized in 2021 with the passage of the Uniform Collaborative Law Act that codified this practice that had been around for about 30 years. So, big difference from a litigated case. The parties are agreeing at the outset and are contracting with each other not to engage in litigation and step before any kind of tribunal, whether that be a judge or an arbiter. They're agreeing that they're going to engage in this process and resolve their case with the assistance of counsel. There's also a team of professionals that we use in collaborative law cases. We have child experts, we have trust experts, we have real estate experts. It really runs the gamut, and based on the needs of the case, we figure out what kind of experts are going to assist the team. There isn't any specialized certificate or training that's required in Colorado. All you have to do is be a licensed attorney and you can practice collaborative law and represent a party in the collaborative law process. With that said, because the law school process teaches us the adversarial system, the cross-examination, objecting to witnesses. So that training is typically provided by the Colorado Collaborative Divorce Professionals. They're the state level, collaborative organization, nonprofit that does training. It's a 2-day training, and they offer advanced trainings throughout the year as well, so you can skill build and really be able to tackle these collaborative cases and find resolution. Yeah, so collaborative law is needs-based instead of positional, right? So even in mediation or in a courtroom, you're taking positions, right? Well, I think the court is going to make you sell the house. So as a result, I want the house sold versus I'd like to find a way for you to stay in the house, me to stay in the house. And so when the kids come, they can both have a similar experience in both houses. So we're having those discussions instead of kind of being focused on, well, what's my best outcome in court? In addition to that, confidentiality, is a big upside in collaborative law cases. So the new CJD, 0501, I should say recently updated CJD, says that we're promoting public access to court records, and we're really making sure that only specific files are suppressed. So as a result, the CJD says, outside of a handful of documents, everything is going to be available for public access in a litigated divorce case. Now, anyone can look up and see what the business value is, information about a family trust that folks thought was going to be confidential. That is all going to be now very difficult to be suppressed. In a collaborative law case, it's confidential. So statutorily, all communications, all expert reports, everything that happens in that case essentially happens in a bubble. And once it's resolved, all the court really sees are the final agreements, which are suppressed. So those facts aren't going to be out there for the entire world to see. Not every case is right for collaborative. So we screen cases. The statute requires us to screen cases for domestic violence. In addition, if there are ongoing substance abuse issues or mental health issues, unless those are managed, they can really throw a wrench in a collaborative case where you don't have, the escape lever of going to a judge or an arbiter. So we screen cases to make sure that they're right for collaborative. And even if those issues exist, sometimes that can be the best place to resolve those cases if we're able to manage them, because we can end up with better results for parties and kids, and it doesn't end up being punitive, right? So codified in the Uniform Collaborative Law Act is a disqualification provision for counsel. So if a case is unable to be fully resolved in the collaborative law process, and you need to go in front of a tribunal, whether that be a judge, a magistrate, a decision maker, an arbiter, a special master, that attorney who represented the party in the collaborative law process and their entire firm are disqualified from representing the party in front of that tribunal. All right? So that means for clients, they have to start over. For attorneys, the loss of the case. All right? In addition to that, the expert reports that are completed during the case, all the communications, all of that is confidential. It's not admissible in the courtroom. And so the parties have to start over there as well. So because of that high exit cost, both time and money, you need to try to figure it out. Otherwise, because of that high exit cost, you really have to start over. But even with that disqualification provision, about 94% of cases, and this comes from a study a handful of years ago nationwide for collaborative cases, 94% of those cases that start in the collaborative process fully settle in the collaborative law process. And of those 4% that don't settle, only 2% end up in front of a judge in a courtroom in a contested hearing. That's a much higher rate than mediation. And generally, client satisfaction going through the collaborative law process is much higher than a court process or even mediation. Yeah, so a couple first steps you can take. So, finding a mentor or someone who practices collaborative law is, and having a conversation. Hey, is this right for me? Do you like the practice? Is probably where I would start. And it is where I started, right? That's how I was introduced to collaborative law. I had a case with someone who practiced collaborative law on the other side, and it was such a great experience. So, one of the best resources we have in Colorado is the Colorado Collaborative Divorce Professionals. There's a membership directory on the website. Any of those attorneys on there are going to be happy to talk with you about how you can get into the practice and what you need to know. Yeah, so starting with reaching out to folks, or getting the training and then meeting people through that process is really how you get into it. And then to grow your practice, collaborative law has a concept called practice groups, and those are small groups, typically 8, maybe 15 professionals, multidisciplinary, right? You have child experts, financial experts, other neutrals, and that is where you kind of learn and hone some of these skills, talk about issues you've had in cases, how you've overcome them, and develop and grow those connections in order to build your collaborative practice.